Welcome to Homely Property Chat, where we talk openly about buying and investing properties in Spain based on real experiences. Today's episode is very special and focused on legal sides of buying property in Spain with a particular look at the new builds and off-plan purchases. We're joined by Kinga, a bilingual lawyer in Polish and Spanish, specializing in real estate transactions and working closely with international buyers investing in Spain. So Kinga supports clients throughout the full purchase process, from reviewing purchase agreements, off-plan agreements, and analyzing mortgages terms and identifying potentially abusing clauses. During this episode, we're planning also to cover some mortgages topics, including common clauses that foreign buyers often overlook, and when it still makes sense to review a mortgage contract even years after signing. So thank you very much, Kinga, for joining us. Let's get started, and welcome to this Homely Property Chats. Before we start, maybe, I would like to hear from you a bit on how you ended up in Valencia and how long you've been exercising your profession as a lawyer.
Hello, Magda. Nice to see you. Nice to meet you. Thank you for your invitation. I've been here in Valencia since 10 years. I'm here because of my husband. My family is here. So actually, I've been working for real estate like since 5 years. So I really enjoy this topic, and I think it will be very interesting today.
Amazing. 10 years, it's a lot of time, and 5 years within real estate with all the changes that have been happening. I guess you're bringing a lot of interesting insights. So I'm really curious to dive in. So as you mentioned, we said in our introductions, you work mainly with foreign buyers and investors in Spain. So from your perspective, what are the legal risks they do systematically underestimate when buying property here in Spain?
In my experience, buyers often underestimate the fact that the legal risk doesn't sit in just one document and at one specific moment in the process. With second-hand properties, many assume that checking the land registry extract, Nota Simple, is enough. It's important, of course, but it's just one piece of the puzzle. I mean, it doesn't reveal planning issues, internal matters with homeowners association, and it doesn't replace the review of contracts you sign before completion, right? And that's often where buyers unknowingly take on significant obligations, right? And with new builds, the misconceptions goes in the opposite side, because buyers tend to think that the property is new, so there is no legal risk. And in reality, the risks are simply different. And sometimes more complex.
Okay, well, thank you very much for this introduction. It's very interesting, actually. So, from your perspective now, like how do you advise people? Like, what you mentioned, like several documents, like is someone even able to do it by themselves, or it's actually almost impossible without the help of somebody senior and experienced in that field, such as legal advisor?
It depends. You shouldn't buy by yourself because you're not able to check it out, everything. From a legal perspective, the key difference, for example, between buying a new build and second-hand property in Spain are important as well. Because the key difference, it's not only the type of the property, but the legal structure behind the transaction. With second-hand property, the contract reflects an existing reality, right? And the property is already built, registered, or sometimes not, physically identifiable. And the legal work focuses on verifying its current status, right? Ownership, charges, community matters, and reviewing the contracts we mentioned. And with new builds, the legal dynamic changes. Even if the property is already completed, the contractual framework is usually more complex and heavily standardized by the developer. The buyer is entering into conditions that are not individually negotiated and that often contain detailed provisions regarding delivery, specifications, liability, guarantees. And when we move, especially in off-plan purchases, which are particular category with the new builds, the risk level increases because the contract regulates a future constructions that doesn't yet exist, right? So I think you shouldn't check it by yourself.
Okay, that's definitely one of the key takeaways, right? Like, current status versus future planning, and then obviously supporting ourselves with somebody with experience, which makes complete sense. And you've mentioned actually what's really interesting for us, because I mean, with the current situation in Valencia, well, not only in Valencia but in general, like with this high demand, all the new builds are selling immediately, and whenever you have the option to buy off plan, it's always seen as an excellent opportunity. So as you know, and probably you've worked with many clients that are very attractive to this off-plan purchases which guarantee you better pricing opportunities, like a lower initial price. And you started mentioning that with the future, like focusing more towards the future. So from your perspective, what are then the biggest legal risk when buying property before it's being built? If you could name them, and make a small list so we can visualize it.
Often purchases represent the highest risk scenario within new developments, because the buyer is committing financially to something that doesn't yet physically exist, as we mentioned. The buyer is paying installments during construction, often long before completion, and the level of protection depends entirely on how the agreement has been drafted. So the most significant risks typically involve construction delays, changes to specifications or layout, insufficient guarantees for advance payments, and clauses that restrict the buyer's ability to terminate the contract if the developer fails to deliver as expected. Another important factor, is imbalance. These agreements are usually drafted exclusively by the developer and presented as standard, no negotiable documents. However, key provisions, especially those concerning deadlines, penalties, and refund rights, can have major financial consequences if not carefully reviewed by a professional, right? And in off-plan construction transactions, trust in the developer is not a substitute for legal protection. What ultimately protects the buyer is not the marketing brochure, but the contractual framework and the existence of proper financial guarantees before any payment is made.
Okay, so there is a lot to unpack here. Maybe starting from the point what you said about this, payment plans and developers, infamous developers. As you said, when you're buying secondhand property, you are dealing almost with one-to-one, whereas when you're buying new builds, like, a lot of non-negotiable aspects of the contract. So as we know, on one hand, it's very attractive when it comes to the payment plan, but developers usually ask for the payments in tranches that are tied to construction milestones. So what in this case buyers should check before, check inside these clauses before transferring any money? And as you said previously, like there is not that much level of negotiation. So what's your recommendation on that topic?
You should check under what conditions that payments is legally protected. Under Spanish law, developers are required to provide financial guarantees covering all advance payments made before a completion, typically through a bank guarantee or insurance policy. However, buyers should not assume that this protection is automatic or properly implemented in every case. So the existence, scope, and enforceability of those guarantees must be carefully verified before any transfer is made. So you should check if the guarantee the developer gives you is really true.
How do you do it?
Checking the contract with
a lawyer. Okay, so the answer is always like go and check with the lawyer before making any serious financial commitment, right?
Exactly. And in addition, the payment schedule should be also clearly linked to the objectives and verifiable construction milestones. Non-vague references like progress of work, and the stages should be measurable and ideally supported by technical certification.
Would you be able to give us some example? For example, so that some of the listeners who have not even considered yet buying, new build developments should look at. So what could be tied to? So like, getting the building off the ground, or there is, electrical system being put in. What are the specific stages that are typically, as you said, visible and verifiable?
It actually depends on each developer. Each developer has its own type of contracts, and you can see a lot of different examples. So there is no like standard. I mean.
Okay. So it's one by one, so even more confusing. And what you were saying also about the delays. So to what
About
extent
what?
we are about the delays? So
Mhm.
we were mentioning that sometimes there is one promise, one guarantee, and then the reality is different, and it's very common, especially here, unfortunately. So sometimes like buildings are being provided like here after the deadline. So what happens legally if constructions is delayed, or any specification change, or the property is not delivered in a status and up to the specification that was promised?
That's why it's very important to have technical certifications, as I mentioned before. But if a developer delays delivery, the first thing we need to review is a contract and include an estimated completion date, and in many cases, a grace period. If that additional period expires without the delivery, we may be facing a contractual breach, as you mentioned. At that point, the buyer's option will depend on what the contract provides. In some cases, the buyer may have the right to terminate the agreement and recover the amounts paid, potentially with interest, of course. In other, compensation for damages may be possible, or the parties may agree to extend the deadline. However, not all delays are treated the same. Contracts usually distinguish between unforeseen circumstances like extreme weather or strikes, and delays caused by the developer's own organizational or financial issues. So the legal consequences can differ significantly depending on the cause. This is why it's so important to review not only the delivery costs, but also the force majeure provisions and guarantees covering advance payments, of course.
Right? So when we review the purchase contract, we basically have to go to speak with the lawyer and then check exactly like these guarantees, and then the exceptions as well, right? Like that these are the clauses you were. So top 3 would be the stages of constructions and promised delivery date, and then what is the sort of guaranteed compensations and under each circumstances in case of the delay, right? If I understood correctly.
Yes. And clauses that determine what happens if something goes wrong as well.
Okay. And then, for example, if there's anything specific that we could be aiming at in the secondary property market when it comes to, obviously you're not dealing with the developers there, but just out of curiosity, we're talking about the new build, all the risks. What happens when you are dealing with the standard purchase contract for the secondary home?
Wow. And then we have to check, of course, a lot of contracts. Like a very special one is arras. So before you sign everything, you should make a due diligence. I mean, you should check the Nota Simple, and of course, you should talk with administrator of the and see whether there is something hidden or not. And if you cannot check all of documents, you should protect yourself in this contract. So that's why you need a lawyer to make it.
Okay. And when you're talking about speaking to the owner, like, should you always be guaranteed the access to this information? Or I don't know, some owners could protect themselves saying like, look, I don't have access to this information. And that's where the lawyer comes in. Like, how does it work in general? Maybe if you could give us some example with some of the clients saying like, look, what happens mostly is when people come to me, it's already too late. They've been not giving the access, or they are struggling to access this information. That's why I step in, and when they see a lawyer, then they facilitate this information. Could you give us a bit of like, the snapshots of what it's like to be really getting a deep dive into documentation beyond the standard, let's say, standard processes?
Okay, so one key area is the declaration of the property's legal and physical status. The contract should clearly address ownership, existing charges, outstanding community deals, and whether there are any planning irregularities or unregistered alterations. Another important clause concerns like defects and liability. In second-hand transactions, the allocation of responsibility for hidden defects or undisclosed issues must be carefully reviewed. Buyers should understand what protections remain in place after completion and which risks they are explicitly accepting in arras, for example. Because most of vendors don't want to give you all information, so that's why you should protect yourself by contractually.
Okay. Do you have any fun story or with a happy ending on when some hidden damages were found after signing the arras and I don't know the solution you've managed to find?
Yes.
Anything?
Yes, normally you have like 6 months since you receive the keys to uh, to uh,
Declare.
declare the hidden defects, right. So sometimes the vendor says no, you accepted the physical state of the flat, but no, that's not true, because some vendors even hide the defects, right. So there's a lot of stories, but if you are on time, you can do it.
Okay. So, but basically, we're going back to the square one, right? So always surround yourself with the right specialists, because then I assume you're also able to anticipate a lot of that stories when you're dealing with the lawyer. Because I always say that in our case, when purchasing the flat, thankfully we've signed the arras already, and then we were bringing specialists to renovate the flat, and then just randomly one of them like hit the ceiling with like a tube that he had, and all of a sudden he discovered that there was like a hole in the ceiling. So obviously the owner was claiming he had no idea that the ceiling was broken and there was flood above, and there was a whole story. In the end we managed to solve it, but it's been a long process, and it took us a year actually. Like the good thing was that the owner maintained the flat for 1 year, so until it was fixed by the community, because eventually it was not considered, since it was a roof, it was not considered part of like his responsibility to fix it. So there's always a lot of interesting things. So I think what you're saying about the hidden damages or hidden problems, and I guess it's mainly the secondary house,
Yes.
secondhand properties, because what's physically there. And sometimes you see an amazing flat being sold at a really good price, and then you think like, what is wrong? What is wrong with this property? There must be something hidden in it, right? So 6 months works for new build and secondhand properties.
No, for second-hand properties. For new builds, it depends on the type of the defects. You have like one year for aesthetical defects. Then you have 3 years for other defects. But like if you want to claim the constructual defects, you have 10 years. So it depends. Each defect has other time. But
Okay.
this is very important. Like the aesthetical can be the paint, So I don't like it. It had to be whiter. So you have 1 year.
But then for that, is that out of curiosity, then it's like a dispute. You go and say like, look, this is supposed to be whiter, on the brush it looks whiter, paint a different color to me. And then like you get inside the negotiation with the developer, and then you see that if you win or not. Like, what's the process out of curiosity here?
First, you should do negotiate with developer, because if you don't, it will be. I mean, you will pay more to the lawyer to go. I mean, to fight in the judge. Always, it's better to try to make an agreement with developer. But sometimes they don't want. So there is no other way to make it. But of course, you should to think, because it is whiter, do I want to pay a lawyer for this? That's not the same as aesthetical defects or constructual one.
What would be the example you can claim and complain about after, let's say, 5 years, when we're talking about constructural damages?
Significant cracks in load-bearing walls or structural beams, foundational settlements causing uneven floors or structural movements, defect in columns, pillars, or slabs, and that's compromise stability, and structural roof failures affecting the building's integrity.
Well, these are some serious stuff. So I really hope not many people have to deal with that, because then I imagine it's like a long process, and plus you feel like you're risking your life every day. But thanks a lot for this example. It always helps us to position the topic and understand it a bit more. Okay, so we're talking about this, bad developers that are being not very flexible with their contracts. What about moving slightly towards the bank and mortgages? So, when we're talking about mortgages and abusive clauses, many buyers, especially foreign buyers, assume that, mortgage contracts are standard and are untouchable. So what are the abusive or sometimes unfair clauses that you see in Spanish mortgage contracts? Something to watch out for.
It is true that mortgage regulation in Spain has evolved significantly over past years, and consumer protection has improved. However, that doesn't mean every clause in every mortgage contract is ultimately fair or fully transparent, as you said. One recurring issue is cost allocation, although the courts have clarified that how certain expenses should be distributed, disputes still arise regarding notary fees, registration costs, or arrangement fees. Another important area concerns default interest and yearly repayment conditions. Even when legally compliant, some clauses can create disproportionate financial burden if the borrower encounters difficulties. I mean, we also see situations where borrowers were not fully aware of linked products, such as insurance policies or other financial commitments that were presented as necessary for obtaining better mortgage conditions. Because the bank cannot say you have to do that. They will not say that. They will say, if you do that, we will make you better condition. So you do it. And the key issue is not whether the contract is standard, but whether the borrower has genuinely understood its long-term financial implications. I mean, a mortgage, it's not just formality. You sign it for 20 or 30 years, right?
Okay. Yeah, that's true. But isn't there like the exam that you have to pass to sort of show that you understand the mortgage that you're signing up for?
Even I don't understand some contracts because they're very, very long. I mean, there are contracts like 50 pages. So who will read it? I mean, you can read it, but do you understand it?
No, exactly. And that's one of the part of the tricks of the banks, right? So I think especially even more when we're dealing, when we doing in a foreign country, what we seeing right now is a surge of foreign buyers that are actually taking mortgages in Spain to cover the Spanish investments. So here is the questions. I don't know if we have a clear answer for, but, are foreign buyers at a disadvantage when signing mortgages in Spain, for example, due to the language or pressure of signing? Because sometimes you have to, you only have this like 90 days from the moment you've signed up at us, picking up the keys when you have to have your mortgage fixed. So, sometimes there is a lot of issues on the way. So, you are being pressured to sign. So how do you see it from your perspective? Is foreigners, when they are signing for a mortgage in Spain, are they at disadvantage, or are they being treated exactly the same way, or they are protected by exactly same law?
Pressure. Foreign buyers are not necessarily at a legal disadvantage, but they can be at practical and financial disadvantage. From a financing perspective, Spanish banks often apply more conservative criteria to non-resident buyers. This means a lower loan-to-value ratio, for example, financing 60 of the property value instead of 80-90. And in some cases, higher interest rates compared to resident borrowers. In addition, of course, a language can be a significant barrier. Mortgage contracts are complex documents, and if the borrower is signing in a foreign language, the risk of misunderstanding increases. And many buyers also review the final conditions very close to the completion, as you said, because of the pressure. And when there is already financial and emotional pressure to proceed. So Spanish law requires a prior transparency process before signing, including a preliminary meeting with, however, that process not replace independent legal advice, because the notary will not read you all of of this contract. I mean, entire contract. He will just mention very fast the most important clauses, and you sign, and that's all. So, but the good news is that mortgage conditions are not always permanent. I mean, once the loan is in place, borrowers may later renegotiate terms with a bank, or even transfer the mortgage to another bank if better conditions are available.
How does it work normally? Well, it probably also depending on the bank, but let's say what's the most standard here? Is it minimum 2 to 3 years that you have to stick to your bank before you can renegotiate and take to another bank, or it can also happen within the same year? I'm thinking also about the penalties. What's the most common that you see among your clients?
Both. Normally, you have penalties if you change to another bank. But now, more banks offer you, like, you should wait 2-3 years and then you can go, because of in Spain now the judge says that this shouldn't happen. So the bank cannot retain you there if you can have better conditions, because you are a consumer. So it is not fair, right?
Is it because of the EU consumer law, or that's just like a standard Spanish law out of curiosity?
It's not a law. It's consumer and what the judge says. There's no written law about it.
Okay. It's just like the standard practice, what we see in most of the examples. Okay,
Mm.
great. And then, like sometimes, people, especially when they watch the movies, they feel empowered to do the same. They go and say, like, buyers, they go and say, I have a lawyer. But, it can mean a lot of different things. So what does proper legal support throughout the full purchase process should actually involve?
Comprehensive legal assistance starts before any contract is signed. It involves analyzing the structure of the transaction, reviewing and negotiating the private agreements, verifying the legal and financial situation of the property, and identifying potential risks before the buyer commits financially. It also includes monitoring payment stages, coordinating with the bank if there is financing involved, and ensuring that all guarantees and documentations are properly in place before completion. So legal support is not just reactive, but it is preventive. I always say to my clients, please don't come to me when you have already signed. Please call me before you do it.
Okay, and that's actually leads me to another questions, So at what point the buyer usually come to you when it's already too late? And then, what's and when the legal risk is already locked. Is there a stage at when you are actually not able to help, or good lawyers always able to get involved and help the client to fight their way?
It depends. Most buyers come too late after signing the private purchase agreement, especially at the deposit or arras contracts, and transferring a significant amount of money. In many cases, they request due diligence only after having formally accepted the legal and physical condition of the property. If during that late review a problem surfaces from the transaction, may mean losing the deposit, right? Depending on how the contract has been structured. At that stage, the legal analysis becomes reactive rather than preventive, right? And another very common situation involves time pressure. Buyers contact a lawyer just days before signing the deposit agreement, when flights are already booked, financing is pre-approved, and there is emotional urgency to secure the property. So technically, the contract can be still reviewed, but in practice, negotiation leverage it's extremely limited. I mean, the safest moment to seek legal advice is before signing any binding document, because if we see that there is any problem, you will lose your deposit because normally the vendor draft the contract on his favor.
What are the red flags? Because, you said that with many things, like you can fight back, you can try to support. Obviously where everything is signed, it's more difficult, but there's always a way. But, if an international buyer is considering buying in Spain this year, so in 2026, what legal red flags should immediately make them pause or walk away from the deal? And maybe we can focus, if we can give like one example from the new build and from the second-hand property.
Okay, the Nota Simple with second-hand property, first alarm is that the person who signed the deposit contract, the arras contract, is not the one who figure on this extract, land registry extract. That's very important, because you will not be able to buy this property from this person. And charges, of course, whether there is mortgage contract without cancellation, it's also important. And with new builds, actually depends. I mean, I will focus more on checking the guarantees, like insurance. This is the first thing you should check. And after that, you can see what the clauses, what happens if something goes wrong. But there is no, red flags, like examples. Maybe if you ask the developer to give you the insurance contract and he say mañana, so and no, tomorrow, no, today, I want this, because this is very, very, very important.
Okay. No, that's great. It does happen very often that there is a different name on the land registry, for example, than it is on the Nota Simple.
Yes, it happens very often, because in most cases of the succession, so you have sometimes 4 people, and there is finally appears the other person who say that has the right to this property. So if you know that the vendor has this property because of the succession, please ask him for the document to see all of the successors. So
Okay.
that's my advice for this kind of transactions.
It's great. I mean, we were buying the flat from the family, and it was 11 of them, 11 brothers and sisters. But
Wow.
they were still alive, all of them, though some of them were at the very advanced age. And at the moment of we were signing up at the notary, they all came. So we actually received the 11 sets of keys, which was kind of funny, because obviously later on they have to change the locks anyway. But yeah, as you're saying, like, the whoever figures on the list and who actually is there for in real life, it's very important for verification. So thank you very much for bringing that over. Okay, Kinga, thank you so much. I mean, it's not an easy topic. It's still a very relevant one. I think people, when they start dreaming about buying the property, they always look at these views and locations and focusing on this enjoyable parts, just like dreaming about the fantastic and new life in Spain. But the legal topics are important, though they are hard sometimes, and they are very demanding. So once again, highlighting here, being able to surround yourself with the right advisors will help a lot any investors along the way. Buying property in Spain very often looks straightforward, and we try to do our best to make it as straightforward as it can be, but there are so many differences in laws, customs and culture. So thank you. I mean, we covered the contracts, we covered the delivery times, mortgage clauses, and I think there is a lot to unpack. I really hope this episode was very relevant to all our listeners. And if you're still listening, if you're thinking about property in Spain and you want to better understand the legal side before committing, we really hope this episode helped you. And we'll share with you the details of Kinga if you wanted to check with her any potential issues, or anything that can potentially go wrong in advance before signing anything. This is how she can make sure that your plea and your case will be a success. So thank you very much for joining us in this podcast, Kinga. It was really a pleasure to talk to you and hear about your examples and experiences. And then if you find, whoever is listening, if you find this episode useful, feel free to share it with anyone that might be considering buying or investing in property in Spain. So until next time, thank you very much. Bye-bye.